Hello, my name's Olurotimi Osha. Today is July the 7th, 2026, and today I want to discuss birthright citizenship and the 14th Amendment and a federal law, and of course, Trump versus Barbara, the decision. Now, while many people are relieved that the U.S. Supreme Court upheld birthright citizenship, and in Trump versus Barbara on June 3rd, the 30th, 2026, I realized just from the media, there's been a bit of a confusion with respect to the two court decisions, right? The two votes. One was 6-3, right? 6-3. The court struck down President Trump's executive order, right? Basically limiting birthright citizenship. And then there was a 5-4 decision in which, excuse me, in which Justice Brett Kavanaugh, who's on the conservative side and who had voted on the side of the conservative, the other, you know, sorry, Justice Kavanaugh, right? In the 6-3 decision, he switched and voted on the side of the progressives, the liberals, well, the progressive arm of the bench, of course, and with Chief Justice John Roberts and Justice Amy Coney Barrett, which made them 6. But in the 5-4 decision in the constitutional matter, he switched and then joined the conservative, some of the conservatives, Justice Samuel Alito, Justice Clarence Thomas, who wrote the dissent, and Justice Neil Gorsuch, right? And of course, and that's Justice Brett Kavanaugh, which made it 4. Now, so people don't understand the difference, the split. So, and Justice Brett Kavanaugh did something, right? He pointed something out, which is, it shows you his lawyerly nature. He's a lawyerly, he's a lawyer, and it's a lawyer's way of thinking. And what he pointed out might have actually been maybe the cleverest bit of the jurisprudence. So in the case of Trump versus Barbara, he pointed out a loophole, right? The vagueness in that phrase, subject to the jurisdiction thereof, right? And so, but by the way, let me get to it. Let me just explain the difference. So it turns out that there is actually a federal statute, right, created by Congress in the Nationality Act of 1940, and then it was reenacted again in the Immigration and Nationality Act of 1952. So it's 8 USC. USC stands for United States Code, Section 1401A. And that just basically, it talks about who's a citizen at birth. And it says all persons, born, in the United States and subject to the jurisdiction thereof, basically mirroring what's in the 14th Amendment in the Citizenship Clause. The Citizenship Clause says all persons born or naturalized in the United States, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens, right? And the states in which they reside, right? So basically, the salient points: all persons born in the United States, that's a concept of jus soli, and subject to the jurisdiction thereof are citizens, right? So and that's exactly what's in in a law that was passed by Congress in 1940 and in 1952 in the Immigration and Nationality Act. So cleverly, well, he points out a distinction. So just Brett Kavanaugh, right, points out that um, while his colleagues, struck down the law saying, based on the constitutional reasoning that the 14th Amendment, the Constitution sort of guarantees or mandates, expressly mandates birthright citizenship. Because that same phrase, right, all persons born in the United States, and it's sort of providing unconditional jus soli. In fact, I should do a video explaining concepts of jus soli and jus sanguinis. Jus soli means birthright by right of soil, right? You have your birthright citizenship based on the soil. You're born in the territory, right? And the issue is, we've sort of been practicing near unconditional birthright. That's birth of the soil, jus soli. So birthright by soil, right? Right of soil. And then the alternative is jus sanguinis. That means right of citizenship through blood or ancestry, right? So America really practices a combination, because an American citizen, for instance, who goes to Germany, is in the military base in Germany, or is traveling in Germany, he gives birth to a child there. If she or a woman gives birth to a child there, her child is still, a citizen, even though the child wasn't born on American soil, right? So that's the concept of jus sanguinis, right? So it's important. So the caveat here, the important question, right? The sticking point here is that subject to the jurisdiction thereof, and it's sort of a vague term, and that's what Justice Kavanaugh is sort of insinuating, right? Because he's saying that, well, he's striking down that the President Trump's executive order is unconstitutional because it violates the federal law, which mirrors what's in the Constitution, right? So in our Constitution, there's a hierarchy of authority, of laws, and we have what's called separation of powers, right? It's Congress, that's Article 1. They're the ones who can enact laws. They're the ones who make laws. They're the ones who create laws. The president does not make laws, right? People think the president makes laws. Now, the president is the person we vote into office, right, to represent us. The president, because he's the leader of his party, can propose laws to the Congress, right? Because he's the leader of the party and he's representing the massive will of the population of America's citizens. So he will propose laws, and Congress will act on it and enact the laws. They'll create the laws, and then of course they sign and they bring it back to him, and he signs the laws, but he doesn't create those laws. Now, he can issue executive orders, but they don't have the weight of law. Their directives, they're not binding, right? They don't have binding authority like laws on the citizens. The executive orders that the president passes, they're only effective, right? They direct federal agencies under his authority and federal employees, right? And he gives them guidance on how to implement or execute those laws that Congress has created, that they're laws, the laws and the statutes. That's basically what he does through the executive orders. So the hierarchy of laws is the Constitution is the supreme law of the land. That's already been established. We have the U.S. Constitution, right? That's the supreme law of the land. And then statutes created by Congress, laws made by the Congress. That's next, right? So Congress passes laws all the time, but they're not necessarily the Constitution, right? So for instance, those regulations, they're created by Congress. And then, and just like this one I just read, that's 8 USC section 1401A, right, which says, citizenship by birth, is for all persons, born in the United States, and subject to the jurisdiction thereof, which mirrors what's in the 14th Amendment, right? The Constitution, it mirrors the Constitution. So the last, right, the last in the hierarchy of authority are executive orders by the president. So, well, the president cannot issue an executive order, right, that violates the Constitution or even overrides statutes, laws that have been created by Congress. The president cannot do that. And so, in Justice Kavanaugh striking down, voting with the 6-3 majority to nullify that executive order ending birthright citizenship, what he did was he said, well, President Trump, right, issued an executive order that contradicted, that was trying to, override an established law by Congress. Congress has already established a law on who has birthright citizenship, and he can't do that. It's contrary, so he doesn't have the ability to do that. But he said he refused. So on the constitutional matter, so there are two votes. One's the constitutional reasoning, right? Because those who voted 5-4, the 5-4 majority, they said, look, their argument was that there was a constitutional violation. There was a constitutional protection of mandate of birthright citizenship. But Justice Kavanaugh said no, he doesn't think so. He said, well, and the reason he doesn't think so, one, it's easy for him to side to merely strike down the federal law, to say it's only a federal violation, because that's a purpose. Because they mirror each other. The law in the statute by Congress, the 1940 Nationality Act, and the 1952 Immigration and Nationality Act, they say pretty much the same thing that the 14th Amendment Citizenship Clause say. All persons born in the United States and and subject to the jurisdiction thereof are citizens, right? They basically say the same thing. So he said that was what President Trump violated. Now, why didn't he think, since he thought it violated the federal law, why didn't he think, since it was the same thing in the Constitution, why didn't he think it violated the Constitution, right? One is because it's vague, subject to the jurisdiction thereof. It's vague. Some people apparently think subject to the jurisdiction thereof just means, well, that that person, the parents or that person, they are required to obey the laws and they can be arrested, and that's what it is, right? And that's part of what subject to the jurisdiction thereof means. But other people think subject to the jurisdiction thereof means owing allegiance to the United States, right? Now, however, in modern nationalism, in the modern definition of national citizenship as we understand it, and the way the United States have used it since Wong Kim Ark, because this same issue came before Wong Kim Ark, the case of United States versus Wong Kim Ark in 1898, based on this whole citizenship thing as well. A child of the Chinese, born to, he was born in American San Francisco, that's Wong Kim Ark. Well, his parents weren't citizens, right? So just the same issue that, President Trump was trying to strike down, right? He was trying to create that law that, well, children whose parents are not citizens, or and he gave all the categories as well, were not citizens. That's been dealt with. But in our laws, we haven't used it that custom, since the law was created, right? Since was it 1868? We haven't used it in that way, right? We've understood it as those not subject to the jurisdiction thereof are foreign diplomats, because of the Congress of Vienna, right, created in 1815, right, which gave foreign diplomats, immunity from laws, right, of states in which they're accredited foreign diplomats. So they had immunity from their laws. So it was understood that that exemption, right, applied to foreign diplomats and every other person, right? Whether they're documented or undocumented, or whether they're travelers, they're all, they all have the rights of jus soli, right? They have birthright citizenship if their kids are born here in the United States, so long as they're not foreign diplomats. That's how we've understood it. But the thing is, in the modern concept of citizenship, right? Allegiance, which some people want to argue, right? Owing allegiance to the sovereign, right? To the authority, to the nation, owing allegiance to the nation, that is not something that's hard and fast with respect to citizenship, being a citizen of a nation. Now, subject to the jurisdiction thereof, right? It imputes two things. It can impute personal allegiance, like it did in the old times, personal allegiance to a sovereign, right? To a sovereign, maybe the king, or territorial jurisdiction, right? Territorial jurisdiction. So if you are in the jurisdiction of a sovereign state, right, then you're subject to their laws. You're required to obey their laws, to obey that authority. You're required to obey their laws. It doesn't matter if you owe personal allegiance or not. So now that phrase, subject to the jurisdiction thereof, right, it means something different today than it did in the 15th century. In the 15th century, when the modern concept of citizenship, or even as we understood it in the 19th century, it hadn't evolved, right? Back then in Europe, right? Again, remember, America has a legacy, a heritage from Europe, from England. The colonies were given authority were established by the King of England, right? By the King of England. So back then, if we go back to the 15th century, if you said subject to the jurisdiction thereof, right, it meant, so there was a king, there's a hierarchy. I've done videos discussing, how English hierarchy and aristocracy. So there's a king, and then he has his lords, his nobles under him. The king owns the land, and his lords, his subjects, his lords are sort of subleasing, right? They're basically renting. They owe allegiance to the king, right? Owing allegiance back then, the concept was, so he has his barons, his earls, his dukes, the barons, and then under the barons has his peasants who are in his jurisdiction, his subjects, right? They're subjects, everybody's subject of the king. Part of owing allegiance and being a subject of a sovereign, of your lord, is you owe him military service. All able-bodied people owe them military service, right? You owe loyalty to them, not just the territorial jurisdiction or the authority of the laws, that you're required to obey their laws. Everybody who's within that jurisdiction is required to obey their laws, but also there was a personal allegiance, right? You had a personal allegiance to your sovereign, to the lord of the land. That was part of the concept of being subject to the jurisdiction thereof, right? So, but clearly, as we've applied it, and clearly in the 19th century, having personal allegiance of loyalty, right, was not what the drafters of that 1868 were thinking of. They weren't thinking of, well, they needed to have that concept, the ancient concept of loyalty in common law, right? Because back then, subject to the jurisdiction thereof meant you owed allegiance of loyalty, right? You take an oath, you have an oath of allegiance. So it's an old concept, that's what it was, but it evolved. It doesn't mean that today, and it didn't mean that oath of allegiance in the 19th century. Now, interestingly, so Justice Brett Kavanaugh telegraphed, right? He was basically signaling what Congress can do to walk around that constitutional issue, because the only other alternative, like the five who were based on on the constitutional reasoning, who voted 5-4, the majority, they thought, look, Congress would need to do an amendment to change anything regarding birthright citizenship, right? But the thing is, subject to the jurisdiction thereof is not defined, it's vague. So there's actually a controversial Harvard law professor Alan Dershowitz. So I read an article of, in which he was being quoted, and he was saying, look, a way for Congress or the president to get to work around that, to end birthright citizenship, is for Congress to just enact a law defining who is subject to the jurisdiction thereof. And that's true. That's actually true. That was what Justice Kavanaugh basically was signaling, right? It's something Congress can do rather than doing an entire amendment, because an amendment requires 2/3 of Congress, right? That's the House of Representatives, right? To first of all pass a proposal to do the amendment, and then it has to be taken to the state legislatures, and they need a 3/4, that's 75%, 3/4 vote, and 38 states in the U.S., right? 3/4 to vote to agree to implement that amendment, which is not, America is very polarized. Our politics is sort of pretty much split 50-50. It's almost it's like a Herculean task. It's almost impossible. It's a hurdle that's almost impossible to overcome. So Alan Dershowitz and Justice Kavanaugh were both signaling a way to work around that is for Congress, which already passed legislation on birthright citizenship, right? They passed a law, a federal statute, which is, like I said, that's 8 USC section 1401A, which is what Justice Brett Kavanaugh and the others also, they've said, well, in terms of federal law, it violated the Constitution. That was the reasoning of Justice Brett Kavanaugh, right? It's something that mirrors exactly what's in the Constitution in the 14th Amendment, right? So if Congress can now create another law they don't need an amendment, but they can just create a statute, just like they created 8 USC section 1401A, and create another statute and define who is subject to the jurisdiction thereof. And they can make exemptions if they want. They can say, well, those who are temporary, those traveling, and those who are not U.S. citizens or national born, or permanent residents, then they're not subject to the jurisdiction thereof. Because up until now, we've assumed that it's foreign diplomats, because it's vague, right? It's vague, and so Justice Kavanaugh's reasoning was actually very good. His reasoning is very good because it's vague. It's vague because we've assumed that it was that actually we have a statute. We have a statute, a law that defines that it says that it's foreign diplomats, and I think it also says like an invading army, an invading force, occupying force, or whatever, that they are exempt. They're not subject to the jurisdiction thereof, right? That's limited. Now Congress can create another law saying, well, people who are not permanent residents or not citizens, they're not subject to the jurisdiction thereof, and they can use the ancient notion of subject to the jurisdiction of as meaning owing personal allegiance to the sovereign, to the state, right? They have an allegiance. They have an oath. They've taken an oath of allegiance. So that means the U.S. government can just conscript them into the army, can draft them and say, okay, hey, if they're going to war, they can draft them into the army. If you're an F1 student, right now, if you have a child in America, they're automatically children, even though you don't owe any allegiance. Because if America goes to war and they create a law drafting people into the military, they can't draft you because you're an F1 student, you're a temporary guest. So what Alan Dershowitz is saying and Justice Kavanaugh was signaling, which is true, is Congress can actually just make a law. That's easier to do. It's easier for Congress. They have a majority in, Republicans, those lawmakers who prefer to end birthright citizenship. They can easily make that law and redefine who is exempt, who is not subject to the jurisdiction thereof. And yeah, so true birthright citizenship, I don't think it will last, right? I don't think it will last, and they would need an amendment just because of this loophole, this workaround that's been suggested, right? We can see we inherited a lot of our our common law from England. England had birthright citizenship, right? Automatic, unconditional birthright citizenship, right? Which is jus soli. But England ended it on January the 1st, 1983. Now, if you're born in England, you don't have automatic citizenship, right? One of your parents either has to be a United States citizen, or you have to be a lawful, you have lawful permanent residency status, right? You're there permanently. And so I think that's where America too is headed, right? So a lot of our laws, our concepts, the common law, we inherited it from England. So England already ended unconditional birthright citizenship, like I said, on January 1st, 1983. So it appears that's where America too is headed. And, it is easier than just amending than having to amend the Constitution. And changing the Constitution is a Herculean task, right? 2/3 of Congress has to agree for the proposal, and then 3/4 of the states, that's 38 out of the 50 states, 3/4 of the legislatures, state legislatures have to agree. That's almost impossible since the country is polarized 50-50, right? The Democrats are not going to agree to that. So there you go. I hope this explains things a bit. I want to stop this because I have a friend who watches my videos and he wants them to be shorter. So I apologize. I've already made it longer. But these are more difficult concepts. So I'll try to do more videos and break them down in bits. For instance, I'll do a video explaining jus soli versus jus sanguinis. My name is Olurotimi Osha, and I will keep you posted. Thank you.